All right, everyone, we're going to get started here. For those of you who have just joined us, welcome to Duke Law Journal's 50th Annual Administrative Law Symposium. I'm Chelsea Capus. I'm the Special Projects Editor for DLJ. And I also just want to take a second to thank co-sponsors for this lunch, the program in public law, which is sponsored by the generosity of Rick Horvitz from the Duke Law School class of 1978. That program was designed to promote better understanding of our nation's public institutions, of the constitutional framework in which they function, and of the principles and law that apply to the work of public officials. So this afternoon we have 3 federal adjudicators, which is the topic of this whole day's events, and we're really excited to have them. So I'll turn it over to Professor Walker.
Great. Well, this is going to be a lot of fun. I'm really excited about this. I'm going to just do really quick introductions, although I will say for the students in the room that my kind of standard advice is if you want to try to figure out how to get somewhere, like if you want to be a chief administrative judge of an agency, or you want to be a federal judge or whatever, I find people who are there and look at how they got there, right? So look at their bios, and I'm not going to go through their whole bios. They're all online if you want to get a sense. But I'll just give you a sense of the panel that we have, and I'll start just right to my immediate left. We have James McHenry, who is the director of the Executive Office of Immigration Review at the Justice Department. Director Henry actually started out at the Executive Office of Immigration Review in the Honors Program, through the DOJ Honors Program a few years ago, and then went over and worked at the Justice Department as a DAG, a Deputy Associate Attorney General, actually then spent some time in the Social Security Administration as an administrative law judge, and also some time at Homeland Security, before he came back in 2016 to be the head of the office. And then the next one down is Nancy Griswold, who is the chief judge of chief administrative law judge of the Office of Medicare Hearing and Appeals. OMHA is what we like to call it. I thought it was really cool. She's been an administrative law judge since 1995, and she's been the chief since 2010. So she's been doing this a very long time. One of the cool fun fact is she was actually the first chief judge of the Louisiana Workers' Compensation Court before she became a federal administrative law judge. And if we had a longer time on a panel, I'd love to hear more about state administrative adjudication. And then last we have Scott Boalick, who is the chief administrative patent judge of the Patent Trial and Appeal Board at the U.S. Patent and Trademark Office. I thought it was kind of cool. He started out in the Navy, ROTC, and then joined a law firm, and eventually became a patent lawyer in the Department of Navy. So if you're interested in patent law, you can even go. I was on the civilian side, but still, along those lines. And then he joined the board. He's been on the board since 2007, and you were just recently. 2 years ago, or?
Well, time flies. It's been about a year that I was official. I was acting for about a year before that, but yes.
So I think we're just going to spend a couple minutes with each of them kind of just introducing what their agency adjudication structure looks like. I'd love to get questions from the audience. After that, I've got a couple moderated questions, but maybe we'll just turn it over to Director McHenry first. That works.
Sure. Thanks, Chris. I'd like to echo the panelists from earlier. My thanks to Duke and the hosts of this. It's been a fascinating conference for me so far, and look forward to engaging with you a little bit during this presentation. As Chris said, I'm the director of the Executive Office for Immigration Review, or EOR, as it's affectionately known. Yes, much like the donkey in Winnie the Pooh. We actually have 3 adjudicatory components, but I'll probably spend most of my time talking about 2 of them. And we have both administrative law judges and non-administrative law judges, immigration judges. The part that you're mostly familiar with, I suspect, are our immigration courts. We have roughly 460, 470 immigration judges nationwide, about 69 or 70 courts. They hear cases to determine whether aliens should be removed from the United States or whether they're eligible for some sort of relief or protection that allows them to stay. Right now, we have a little over 1 million of those cases pending, but our judges have actually made tremendous progress in getting the completion numbers up, actually getting through the cases in the past couple of years. Depending on the outcome of that case, it can be appealed to what we call the Board of Immigration Appeals, which is our administrative appellate tribunal. They've right now got about 70,000 cases pending. Obviously, as the cases adjudicated by the judges go up, they go up at the appellate level as well. That third component I mentioned with the ALJs is called OCAHO, the Office of the Chief Administrative Hearing Officer. They have sort of a niche jurisdiction over certain types of fines that are imposed, typically against employers. They also handle certain types of discrimination cases. They're fairly small. For the last 20 years, we've only had 1 or 2 ALJs in there. You know, they hear anywhere from 40 to 100 cases per year. And that's about it in terms of our structure. I guess I'll save anything else for questions.
Great, yeah. Judge Griswold.
So I've been the Chief Administrative Law Judge for Office of Medicare Hearings and Appeals for, it will be 10 years March 1st. So, and I should also thank you. I am really thrilled to be here. You know, I've heard about this, and it's really exciting to be here with all of you. So thank you for the invitation. And it is, we call it OMHA in federal government. We love these acronyms, EOR and OMHA. And it's not Omaha, which is in Nebraska. And people thought when I took this job that I was moving to Nebraska. And I said, no, it's Washington, D.C. But anyway, OMHA. And we hear the third level of appeal for all denials of payment for Medicare benefits. And so they can come from the actual beneficiary. Appeals can come from providers, suppliers, hospitals, doctors, durable medical equipment, prescription drug. We also do a smattering of other things like entitlement appeals, calculations of income-related monthly adjustment amounts to Medicare payments, those sorts of things. I said we do the third level. The first 2 levels of appeal are in the Centers for Medicare and Medicaid Services, or CMS. That is when you talk about, or I call it administrative separation of powers, really, thinking of it that way. CMS is the policy-making arm for Medicare, and we're sort of the quasi-judicial arm. So the first 2 levels of appeal are at CMS, and they are done by contractors. So I think that's an interesting dynamic. They come to us on de novo review. It's and we have administrative law judges by statute, which is interesting. I think we're the only agency where administrative law judge adjudication is in the statute, but it is there. We are supposed to be deciding appeals within 90 days of filing. That is the legislative expectation. That has not happened for most of my tenure. When I came to Medicare, I thought I was coming to a very sleepy little agency that was processing cases in 90 days. Within 2 years, we had a 1,222% increase in appeals, which means that we went up from about 70,000 appeals per year to over 474,000 appeals per year. With virtually the same number of adjudicators. So when we talk about challenges to administrative adjudication, I think the ability of the agency to respond through the budget process to these dramatic shifts in workload is one of the practical challenges that really doesn't get discussed, but it's huge, and I think the other panelists would agree with that. So the fourth level of administrative appeal is also, interestingly, a de novo appeal, but it's an appellate level. It's at the Medicare Appeals Council, which is a separate agency within the Department of Health and Human Services, and it is in a group called the Departmental Appeals Board. So they also have a de novo standard of review. And that's the final administrative level, and then appeals can go to district court. Interestingly, there is and has been for, I'd say, the past 5 years, a proposal in the president's budget to change their standard of review from de novo to a more appellate review because they don't do hearings. It's a, review on the record. But that has not passed yet. It's also in this year's budget.
Well, can I ask one follow-up? So, what are the cases about? What are they like? And who brings it?
Yeah, so most of them, I'd say, well over 90% are brought by providers and suppliers. And what has happened, a Medicare beneficiary will go in and they will get services. My mother had a broken shoulder. She's 98 years old. She goes to the hospital. The hospital treats her. They do x-rays. She has a follow-up visit with the doctor, so now we have a doctor's visit. She doesn't have to pay for any of that out of pocket. They provide the services, and then they will submit those services to Medicare. Medicare will look at them and decide whether or not they were reasonable and necessary, and then decide whether or not to pay them. If they decide not to pay for those services, then the provider or supplier can appeal. And that's when they come to us on those disputes. So that's the vast majority. There are also some pre-service appeals where it's actually the beneficiary that is filing the appeal. Those are usually for medication that is necessary but not approved under Part D. So that would be it.
All right, and then the Patent Trial and Appeal Board is one of two administrative adjudicative bodies within the U.S. Patent and Trademark Office. We adjudicate cases in the patents area. The other board is the Trademark Trial and Appeal Board. Our name is generally pronounced PTAB. If you want to irritate a TTAB judge, call it the TTAB. They don't like to go by that name. We at the USPTO is part of the Department of Commerce, but unlike the rest of the department, we are 100% user fee funded. So all of the operations at the PTO are obtained through various fees that we charge to the users. And there's a pretty strict wall between the trademark fees and the patent fees. So we are funded by the patent fees. We have two kinds of proceedings, and it has to do with where you are in our process. The main function of our patent organization is to issue U.S. patents to applicants who meet all the requirements of patenting. Now, during that process, this is done by about 8,000 patent examiners who they spread the workload out by technology among all of the patent examiners. So there are groups who do chemical and biological, mechanical, electrical, business method kind of applications, and the examiners tend to specialize in an area. And so if you're a patent applicant and your application gets rejected twice, you can appeal to the Patent Trial and Appeal Board. That's our appeals jurisdiction, and that makes up the majority of our work numerically. Certainly we get anywhere between 6 to 8, maybe 9,000 appeals every year. We sit in a board of 3 judges in the appeals, which is sort of common in appeals to have multi-judge panels. Our judges are by statute required to be people of what they call competent, legal knowledge and scientific ability. So what that boils down to is the judges are not only lawyers, they also have to have some sort of science or engineering background or equivalent coursework. If you don't have the degree, you can get equivalent coursework to qualify. And we tend to hear our appeals divided out by technology, not quite as fine-grained as the examining corps, but we have groups of judges who have experience or education in different areas, and some of them can sit in many areas just due to either their education or their experience. So that's our appeals jurisdiction. We also have trials jurisdiction, which is where most of the spotlight is. If you read about us, you're probably reading not about our appeals, but about the trials. We've had trials for a long time, just nobody paid much attention to them. They were called interferences, and it was before the American Invents Act passed. It was a priority of inventorship contest using some fairly arcane and specialized rules. You didn't dabble in interferences. You pretty much had to be all in. But with the American Invents Act passing, we went from a first to invent to a first inventor to file system. Interferences, by the way, we still have about a dozen of them still kicking around. And you may have read our more famous ones are the CRISPR technology. It's a gene splicing technology that has drawn a lot of press. So those are the majority of the interferences we have left. We gained a new jurisdiction, just sort of started up, from basically from scratch in these American Invents Act trials, where what's happening there is once the office issues a patent, there can be different ways to challenge it. Before the AIA, there was, and there still is, a system called reexamination where you can get an examiner at the patent office to re-examine that patent. Either the owner of the patent or some third party can do it. The patent owner also has another means to bring their patents back. It's called reissue. If there was a mistake, it was either too narrow, too broad, they can bring it back, get the examiner to reissue it. The new jurisdiction that came with the American Invents Act, and we started conducting these trials in 2012, about a year after it passed in 2011, is where third parties can challenge an issued patent. We conduct a trial under statutorily mandated timelines, so it's pretty brisk. It was meant to replace a very sometimes lengthy inter-parties re-exam system that went out the door when the new American Invents Act trials came in. Just to give you an idea of why that was probably a good idea, we still have a number of those appeals of inter-parties re-exams still before us about 8 years after the passage of the American Invents Act. So these trials are also conducted in a group of 3 judges. Only the final decisions required to be issued by 3 judges, but we think it's a better practice to staff the trial with 3 judges all the way along so that they're familiar with the case. There's sort of 2 phases. There's a first phase where there's a decision made whether to institute the trial or not, and then if there is an institution, whether we're going to conduct it. And so we've so far met all the statutory timelines. The numbers are quite a bit less. We get about 1,400 of these AIA trials in a year compared to the 7,000, 8,000 appeals. But even that is just to give you a perspective of the volume that the Patent Office handles. The office gets about 600,000 patent applications every year and issues on the order of 300,000 patents. So what we're dealing with is a much smaller slice of the overall patent landscape. The judges, we have just under 260 judges. They, both in trials and appeals, are divided generally by technology. Geographically, the PTO recently opened after the AIA passed 4 regional offices. So we have judges in Detroit, Michigan, Denver, Colorado, Dallas, Texas, and San Jose, California, in addition to a number who are on full-time telework, pretty much almost anywhere within the continental United States. I don't think we've got anybody in North Dakota, but pretty much anywhere else you can find one of our judges on full-time telework, which means that we conduct our hearings largely through video conferencing technology, because when you draw a panel of 3 judges, you're likely to have at least one who's not physically present. And so our hearing rooms are set up with sort of video conferencing technology so that they can appear And we do our records are all stored electronically, so the judges are able to access their working files online, and which makes for a little bit of a different dynamic than when I started in 2007. It was pretty much everybody was physically in the room with a stack of paper in front of them. So it's interesting how things have changed.
Awesome. Well, I'm going to ask kind of one question to get us started off, and then I think we'll have quite a few questions from the audience as well. I'll just kind of have the disclaimer of, I've told them they should just answer any questions they feel comfortable answering. Chief Judge Boalick just found out from the Federal Circuit that he's now removable completely at will.
Never been under the impression otherwise. In fact, an interesting icebreaker. I may have the distinction of being the only person in the room who's been twice declared to be acting unconstitutionally. So it's a little party conversation.
But I do hope that one thing is some of the questions might be specific to agencies, but I'd love for us to have a discussion of if you see something with your agencies as well that has some overlap or something similar. But I'll just kind of get us kind of kicked off and just kind of ask you, in the current landscape of administrative adjudication, are there certain challenges or innovations at your agencies that you have, that your experience, you're kind of working through that you can talk about? Maybe start with Director McHenry.
Sure. I'll talk first about an operational challenge, a couple of operational challenges, then a legal challenge. And I'll actually piggyback off of something Judge Boalick just said. What he experienced in 2007 is largely what EOR was experiencing in 2017 in terms of technology and paper files and things like that. I mean, that was our biggest challenge when I became director. I think we're the last adjudicatory agency in the federal government that had not embraced electronic filing, electronic files, or things like that. And over the past couple of years, we've started moving that in the right direction. We've actually rolled out an electronic filing system to about 15-20% of our courts. We should have close to half by the end of this year. So we still have, many of our judges still hold hearings in rooms with lots of large paper files. That takes up space. It costs money to ship the files. And it's just, I hate to sound sort of blasé about it. It's so last century, literally. Everybody else has embraced the technology. It's easier, it's more efficient. We get the hearings done better. That's been one of the biggest challenges. The other one operationally is we don't control our docket, and I think that's true of most of my colleagues as well. So external factors will largely influence how many cases we get. We can't control necessarily if there's going to be a surge or a glut at any particular time. And in the government, it's hard to plan more than a few months in advance because you never know what may strike or what may happen. As you may or may not know, the Department of Homeland Security files cases with our courts. And each of the last 3 years, they have filed a record number of new cases by a considerable amount. And in fact, they filed about 500,000 last fiscal year. That's something that obviously in 2016, 2017, no one was predicting or could have been planned for. So now we're sort of having to play catch up. You often, if you talk to administrators or people in the government, you'll often hear the expression trying to turn a battleship or an aircraft carrier. Maybe Judge Boalick can tell me what the better naval expression is.
That's a good naval expression.
But that's often what it's like. You're sort of, if a policy changes or an operational reality changes, you're sort of 6 months to a year behind already just based on how the government works. So it sometimes takes a couple of years to move around. The positive news is, we've been doing this now I've been there just about 3 years, and we are starting to see progress. We're starting to show tremendous results. But it's not something, especially when you have a high volume of cases, it's not something that unfortunately can be done overnight. On the legal side, the biggest challenge I think right now is Chris may say the absence of Congress. I'll focus on the litigation. That most of the law in immigration especially, but I think it's true in a lot of other areas, is not coming from Congress. It's coming from either the administrative state or it's coming from the courts. And we've seen a significant uptick in litigation, probably over the past decade, so that our judges, they have multiple authorities, there are multiple sources of precedent for them. So they may have a precedent, an internal precedent they have to follow, but then there may be litigation in a district court somewhere else in the country that issues a nationwide injunction. They have to also follow that. But they may also be in a circuit that issues a somewhat contrary opinion, And they have to kind of reconcile all three of those, and then occasionally the Supreme Court steps in as well. And it's become more and more challenging, especially in the immigration arena, because you've seen more and more suits, you've seen more and more cases getting up to the circuits, and the judges, over the span of maybe a month, they may end up having to deal with 4 different precedents. And just sort of keeping track, staying on top of all of the law and all of the changes is almost a day, it's at least a weekly, if not a daily occurrence for them. And that makes it also difficult to sort of plan and provide for proper operational support too, when you don't necessarily know what the legal landscape is. So I think those are probably, at least from our perspective, the three biggest challenges we have right now.
So I'll make you feel better. We're trying to go digital too. So we have been implementing a system called eCape. Everything has an acronym.
Ours is ECAS, so very similar, very similar.
Yeah, the electronic case adjudication processing environment, and one of our IT people came in the other day wearing this huge blue cape. She was trying to resolve some problems, and I said, okay, if that helps, I'm okay with that. So we are trying to put in place an appellant public portal so that folks can come in and file electronically. And up till now, it has been in paper. We've rolled that out to a pilot group of appellants to have them help us kind of design it. And in 2020, we hope to get that rolled out to all, to the whole country so that everybody can use that. I'm going to kind of piggyback on the earlier discussion for my big challenge, because it really is a practical aspect of what Professor Barnett was talking about. And that is, as an agency head, because I have kind of an interesting role. I'm Chief Administrative Law Judge for now 150 judges. I'm also the agency head for the Office of Medicare Hearings and Appeals. So I have oversight responsibilities, and yet I am now supervising inferior officers and trying to figure out exactly what that means. Because when I was supervising employees, it was very clear to me what that meant. But now as inferior officers, ALJs have they still have employment obligations, and I still have some employment oversight that has to take place. Nonetheless, they have this new status as inferior officers. So here's the challenge from my perspective. And I have dedicated an entire career, first in state government and then in federal government, to protecting independent decision-making for the administrative judiciary. And I feel very, very strongly about that from an integrity of the system standpoint. So we'll start from that perspective. But what does that mean in the administrative context, and in particular now that we're dealing with inferior officers? So what we've always said is that ALJs have qualified decisional independence, which means that no one will interfere with their application of policy and law to the facts of a particular case to reach a particular result. And the APA protects that. But they are obligated to follow policy because they are not the policy-making arm. That's CMS. And they sign on behalf of the Secretary. So they have to follow policies. So the tension comes when you have an ALJ who is skirting making policy in decisions by not following policies that CMS has made. And so how do you deal with that in this new landscape? And that comes right up against the removal protections and the disciplinary, the adverse action protections that were talked about earlier. Now, in addition to that, you also have these employment obligations. And by that, I mean, time and attendance. They have to work 40 hours a week. They have to earn their keep. What does it mean to say that an ALJ is not using those 40 hours a week if they're not working hard enough? How do you figure out what that means? Where does oversight of productivity step over into decision-making and caused some problems there. So I feel like I have obligations to make sure that taxpayers' money is spent well and that people are working when they say they are working and they're earning their pay. At the same time, I want to protect this qualified decisional independence aspect of it. So for me, that it has always been a big challenge as a judge supervising other judges as part of the federal administrative system. I think it's more complicated now.
Sounds like a really good law review article.
Well, I throw it out there too. That I've got the brain trust. Y'all go with it because I think it's an interesting question.
Right, and I don't know if I have a lot of good news when you finally do get to the electronic filing. Usually the system you get leaves some things to be desired, which is sort of where we are is in the process of trying to plan some improvements to the system. Namely, it does fine collecting documents and taking your filing fees. What it's not doing so well is giving us access to the underlying data that's now sitting in the system, sort of as if we're a boat on the lake and we can't get any water to drink other than, manually going in. And so we do, a number of, data reporting and that kind of thing, but right now we're not really aided by our system. It's a fairly highly manual, labor-intensive process to come up with our statistics, or we've done a number of studies, but really unaided by the electronic system. And we're trying to change that, but any kind of endeavor, in the IT world, and especially in the federal government, IT is a multi-year, planning and execution process. So that's, just a technology challenge. We have, the predicting workload, I think, is really kind of a common challenge, I think, among all of us. We really don't know from year to year how many proceedings we're going to get. We have a little bit better handle on the appeals because we look at the patent application filings, and at least we have some historical models for what the percentages are of those filings that end up coming through, getting rejected, and then come up for appeal. So we monitor the number of appeals taken from the examining court, and we're looking at what the trends are in the filing to kind of better predict our workload. So we're pretty good at doing that. The AIA trial prediction really is just very hard to do. It's influenced by a lot of different factors. One is that it tends to be that somewhere in the high 80% of our trials, and we have different types, but one of them dominates all the others. It's the inter-parties review, so I'll just talk about that. 80-some%, depending on who studied it and when, are involved in corresponding district court litigation, and we are, viewed as an alternative to resolve the patentability aspect. We can't substitute for other aspects of district court litigation like infringement or damages, but on the validity of the underlying claims, that's sort of where we can usually come up with a decision faster than the district court. And we have limited discovery, so the expense is not the same as corresponding district court litigation. Nevertheless, we do look at litigation trends, but it's kind of hard to figure out how that maps to our filings, and then different policy choices and different court decisions have an impact on our filings. Just to give you an example, we recently went through a rulemaking to change what's known as the claim construction standard. It's basically how we interpret the patent claims and what standard we're going to use. And there's a standard that the Patent Office uses during examination that's a little bit broader, and the district courts use one that's kind of generally understood to be narrower. And because of this matching of a large overlap with district court cases, we changed our standard in the trials from the standard the Patent Office usually used to this new narrower standard. It helps harmonize with the district courts. The day before that rule went into effect, we basically got nearly 2 months worth of filings in about 2 days. So we got this nice little spike of applications, corresponding crash the next month, and then it sort of leveled back out, but at a level that was somewhat lower than it had before. And so as the trials have evolved, as happens when you stand up a brand new system that's never been in existence before, we've had, and we knew this would happen, evolution along the way, both in the cases from our reviewing court, policy and rulemaking choices, all of which impacts how the applications get filed and how many, and it's been a little challenging. I will say the good thing is right now we're pretty well matched with the size of our judge ranks to the work we have, but it's always tricky to figure out what's coming next.
Cool. Well, I'm going to open it up to questions. I've got more questions, but we've got 25 minutes left. Yeah, in the back, Stuart.
I'm interested in what policy levers you might think would be most efficacious from a centralized place, sort of from the White House. So let's assume that the statute is ambiguous as to something and that there's no regulation on point. And let's assume that any given presidential administration thinks that various kinds of adjudicators have been insufficiently wary about certain kinds of claims that they think are people are systematically over, inflating things or misrepresenting things, they have incentive to lie, whatever. So whatever it is, there's a new administration, they think they've got a beat on this, and they really feel like the adjudicators need to take into account a different way of thinking about the evidence. Again, let's assume it's totally consistent with the statute. It's just, you should recognize that these kinds of claimants tend to lie about this kind of thing, and we feel like we have some information about that. So what are the policy levers they can do that would impact you? So obviously I know one thing is the agency itself can have a rule, and it can promulgate a rule that says we now have a new policy orientation toward this. We can have a legal interpretation of the statute, etc. Is there anything that can happen in a more centralized way that would impact you, not just at the agency level?
That's an interesting question. I mean, one thing that we've heard about is sort of how disparate the different problems are that we're working on. I'm struggling to imagine a hypothetical situation where you would, at, say, the White House level, say, I see this as a problem for all of the administrative adjudication. But a couple of the policy levers, as you say, is that, one, the administration can engage in rulemaking. There are the ability of our director of the agency to set policy or interpretations that the agency follows in interpreting the law. In fact, we've sort of done that recently in a couple of different ways, where we had splits at the board reading some passages of the American Invents Act that I think could be read, in different ways, and through we have a precedential opinion process where we can make cases precedential that bind, the board members, thus trying to, come out one way or another. Of course, there's always the possibility that our reviewing court's going to see these things differently. But at least there will be uniformity there if they see it differently, but then that becomes the controlling precedent. So those are, I think, a couple of different ways. One thing that we do try to do is give guidance to the parties that appear in front of us. We have a trial practice guide where we try to explain there's some discretionary elements in the proceedings. When we decide to institute, there's an element of discretion, and we've been trying both through some of our decisions to point them out, either by making them precedential or what we call informative. They're non-binding, but are just illustrative of what we think a good practice is. And also this practice guide where we explain ways in which the director wants to use discretion to either institute or not. So we have, for example, put out some precedential opinions that list a number of factors that the board considers when deciding how to use the discretion in order to help explain that.
Let's go. Yep, Jennifer, yeah.
Great. So thanks to you all
Students,
for being
definitely
here.
jump in if you want to ask questions. I see lots of professors excited.
So I wanted to pick up on Director McHenry, what you were saying about just some of the legal challenges flowing from the complexity of immigration law in this age of litigation with conflicting and multiple authorities. And I would add on to that just the existing statutory complexity of the Immigration and Nationality Act, which has been compared in complexity to the tax code, as well as just the particular moment that we're in. As well as the absence of the right to government-appointed counsel in the immigration context, and the fact of detention in some immigration courts. And I wanted to ask you in particular, although other panelists could weigh in, on the question of institutional competence and decisional competence, because one could say that, given all of those factors, particularly the absence of the right to government-appointed counsel and detention and the high-stakes nature of many immigration decisions, the need for decisional competence is greater than ever. Earlier in the day, Chris had a slide showing the number of recent immigration court hirings, and you could couple that also with a smaller number, but a sizable number of resignations of immigration judges as well. So I guess my question for you is just, to the extent that ensuring institutional competence is part of your mandate in your role, what are the tools that are available to you, and how do you balance that concern against the also pressing concern over efficiency and addressing the current backload in immigration cases?
There's a lot in there to unpack, so I don't know if I'll be able to tackle quite all of it. I think the first thing I would say is that I don't see decisional competence as unique to the immigration front, and I think my colleagues would agree on that. I think every administrative agency, federal, state, what have you, wants competent administrators, competent adjudicators. That's why the hiring process is so rigorous. That's why we look for the best and the brightest. There's a lot of training that goes into it. There's a lot of quality control, a lot of quality review. So I don't think that's unique to immigration, especially because I'm not aware, you mentioned counsel a couple of times. I'm not aware of any administrative agency that actually provides counsel for anybody who appears before them in their adjudications. I may be wrong, but not to my knowledge. And I was in ALJ at the Social Security Administration, and I've engaged in many discussions, debates with my colleagues over which one has the more complex body of law. I know the quote you're referring to about tax law, but if you ask a Social Security practitioner, if you ask a patent attorney, I think most attorneys would say their particular body of law is the most complicated. So I don't know if there's any way to objectively say that immigration is more complex than others. But to your larger point, the biggest thing is ensuring that you're hiring quality people. We go through a merit-based hiring process just like every agency does. It's a common myth that immigration judges are at-will employees. They're not. They can't be fired for no reason. They have MSPB protections like ALJs do as well. So they're insulated. They have decisional independence by regulation, which is binding. So we want to make sure when people get into those positions, we expect them to be there a long time. We want to make sure that they're the best people that we can get. So we provide training. We monitor decisions. Obviously, efficiency is important. There's also a common myth that judges can be either fair or efficient, but not both, and I don't think that's true. I think most agencies grapple with the same things. I've noted with interest my colleagues talking about they have statutory timelines or statutory deadlines that they're supposed to be meeting to get their cases done. And this couple years ago, we sort of tried to institute our own kind of soft case completion goals, and people thought we were closing the courthouse doors to everybody. So some of it's a matter of perspective. Maybe immigration's a little bit different than the others. I don't think so. But I think some of it cuts across all of the agencies. You hire good people, you train them, you try to give them the best tools like electronic filing, electronic resources, and making sure that they're doing cases both fairly and efficiently. And if you can do that, you can't control the external factors. I mean, I can't control how many new cases come in, but we can control, how well our adjudicators are following the law, how fair they are, and how efficiently they're behaving. And I think that's what leads to institutional confidence.
And I would just add to that, I think that the way that we hire ALJs, that is or hire adjudicators, that's the starting place. But then at Medicare hearings and appeals, we also have 2 weeks of solid training at the beginning, substantive training and training on doing hearings. We also have a yearly judicial education symposium where we go over developments in the law, new things that have happened. We do refresher training. And we have a quality review program where decisions are reviewed by peers, and there's a huge, long checklist of things that they look at to make sure that we're complying with our own policies and due process, and the results of that informs training for the following year. So there are also some things that I think agencies do along the way to ensure or to increase institutional competence.
Speak to about, although it's not quite the same thing, but that since you're talking about hiring and training, just to sort of say what we what we do is again the judges have to have both their scientific and legal backgrounds, and we are careful in who we hire. It makes a difference in how people work, because they've got to work in a panel of 3, so they have to understand that the environment in which they're coming into. We're not currently hiring, but when we were, the last batch we had over 300 applicants for 10 positions, so we do get fairly large number of applications, which we're very fortunate to be able to do that. Training, we have at least 2 times a month, we have a sort of a get-together to talk about the latest cases coming from our reviewing courts and other sort of legal developments, important cases, or we talk about situations that other judges have seen arising to try to see if there are new trends emerging and that sort of thing. So we do get together pretty frequently for training. And the last thing I might add, just speaking of hiring, I know it's not so much on the judge hiring. We typically hire, people have, we don't have a minimum amount of experience. We generally don't hire anybody with less than, say, 7 years. And it's interesting because they come from all walks of the profession, from people who grew up as examiners in the patent office and came over to be a judge, to people who were litigators at big firms, small firm practitioners, solo, corporate counsel, licensing. So pretty much all the different areas. We have a pretty diverse mix of backgrounds in our judge ranks. But one thing they all have in common, and it's also with our other opportunities, is a website that anybody who wants to work at least at the patent office, and I think a lot of the other agency positions which is the usajobs.gov, which is one if you're interested. There's a lot of things you can do to set up job searches, and so we do have some entry-level positions, mainly in staff attorney, and we have a few, 4 to be precise, law clerks for 260 judges. So there are entry-level jobs elsewhere in the agency. So if it's something you're interested in, happy to talk to anybody afterwards about that.
All right, let's go over here first.
In one of the earlier panels today, people were talking about the sort of exceptionalism norm and ideas about having greater sort of procedural uniformity. And I was wondering if you all had any thoughts about how a proposal like that would map onto your sort of respective agencies.
So, I liked it that when they were talking, they talked about sort of having a procedural floor for what's required. And I think that would be a good idea. At Omaha, I don't think that would really change much of what we're doing. Now, the interesting thing with Medicare was that when I came there in 2010, there was no manual for procedures at the organization, and we have spent a considerable amount of time trying to get 68 ALJs on the same page, and now it's 150 on the same page to do things the same way, coast to coast. Simple things like, you know, the exhibiting of the file and the order of the exhibits and that sort of thing. It wouldn't cause me any angst. I do think there needs to be some flexibility, and I heard the panel speak to that. But the idea of having some minimum standards for what's being done, I think probably is a good one. That's my 2 cents.
Yeah, I don't know with us that it would change a whole lot. I mean, we have a practice manual we've had since 2008. We have fairly detailed procedural regulations already for both the immigration courts and for our ALJs. So it would depend on the specific proposal. Obviously, there would need to be some flexibility, but I think a lot of the agencies already have this or are in the process of developing it already.
So you all talked about how there's you make sure that everybody you're hiring as ALJs or adjudicators has a certain level of competence. But I was wondering if you felt that there might be like a selection problem in that, like, especially for immigration, like the judges who apply to be immigration judges are going to have particularly strong beliefs on like the issues there. So insofar as like the problem is like treating similarly situated litigants similarly across judges, if you think that there's a way that you're able to control for the judges, they're all going to be competent but have strong beliefs one way or another, is why they're applying to work in, for example, immigration.
I think there are 2 ways of looking at that. One, and again, I think this is probably true at every agency, anybody who applies to the agency has a strong interest in that agency's subject matter. So you're always going to have people, almost by definition, who have an interest in it. The problem is figuring out beliefs. It's against the law to hire people based on any sort of political or partisan affiliation, and there's no way to kind of test somebody's beliefs. I'm not sure there's a practical way to test it anyway. So at least in immigration, and I think it's true elsewhere, we don't look for any particular set of beliefs. You know, we look for competence, knowledge of the law, which you can show through experience. But beliefs, even if it were legal, I think is too amorphous a concept to try to get into.
And also, I think you get into, there were a series of cases, some that came out of Social Security that dealt with what was called generalized bias. And so I think your question kind of goes to, for any adjudicator, because we can't get into the head of an applicant, and there's no question we could really ask legally that would get us there. It really is something that you look at after the fact. And if somebody demonstrates a generalized bias against or for a group of litigants or applicants, then I think you've got a problem. And Social Security, I know there was one case where there were some ALJs where that did come up, and Social Security had to rehear a bunch of cases because of those generalized bias allegations.
Did you still want to? Okay, so we'll go there, and then John, and then Adam.
So I have another question for Director McHenry. We talked a little bit about procedural consistency, and then you talked a little bit about consistency among, like, with results. And my question is mostly about how different immigration courts have kind of drastically different rates of certain things like granting asylum. We talked a lot about the different and conflicting overlapping precedents. And I don't know if that's contributing to it or what you think might be driving this from your perspective, and whether or not you view it as a place of concern.
Speaking sort of beyond immigration, and again, I won't speak for my colleagues, but I think they would probably agree. I think every agency tries to look for consistency among its adjudicators. I think that's sort of a hallmark of any court with multiple judges hearing the same types of cases. You're never going to have perfect consistency. I mean, there's too much variation in the facts. There's too much variation in sort of individual judicial decision-making techniques. But you try to get as consistent as you can. You promote that through training, through consistent policies, reminders. If there are complaints filed that raise issues, take corrective action, that sort of thing. In the immigration context in particular, we could probably debate all day as to whether there are wide disparities, great disparities, significant disparities. I know that assertion has been out there, and it's been out there for a while. Our numbers show that the disparities aren't quite as great as people think. but that gets into sort of methodological assumptions and database type analysis. And I think if you don't agree on sort of the fundamental data, you're never going to agree on the outcome. So each of us may think a completely different result simply because we're looking at the data differently. So I don't think there are great disparities. There may be one or two outlier courts, but they're not quite as great as people think. But I understand other people have different views on that.
John and then Adam. Yeah.
So I wanted to ask a question, and this is partly to Chief Judge Boalick, but Chief Judge McHenry also mentioned this in his comments earlier on, of saying that the judges, the immigration judges and the patent judges had, or at least for patent judges, had tenure prior to the Federal Circuit's ruling. And I must say, I'm trying to puzzle through that. I've tried to puzzle through that with the patent judges, and I'd also like to hear about the immigration judges, because you actually said in your comments that many people think they don't have tenure, and that's wrong. So the situation with the patent judges, ignoring the most recent Federal Circuit decision, is there's a statute that's in the patent code that says everybody in the office has to be hired under Title V. And that really doesn't tell us, that doesn't give you tenure, because lots of people get hired under tenure Title V who don't have tenure. And then you go to Title V, and it's not clear to me exactly how patent judges were hired. What OPM? I mean, because that leads you to Title V, and that's the domain of OPM with respect to personnel issues. And I hate to get too technical, but I'm kind of very curious about this for obvious reasons, because this is, this is part of the litigation, and I don't want you to comment on the litigation, but just what does OPM tell the judges? Because this is very non-transparent about, OPM can classify jobs as, for example, Schedule C, which everybody calls political appointees, but in fact, I think the statute says policymaking people. I think that's the statutory basis, which you could say a judge, in areas where there's not clear policies, does make policies, interstitially, but nonetheless makes policy. So I'm just wondering, what does OPM do, or is there some other statute in Title V that I'm missing where for sure these judges who are not ALJs have tenure protection bolted into the APA. For people in both the patent office and I'd like the immigration office too, I'd like to find out where the tenure is coming from. And I'm just curious about that. So I guess Boalick maybe.
Yes, so maybe just to start so tenure, which I don't, if I said tenure, that's not something that I had meant. What I had always understood, at least until a recent decision of which I cannot speak, under at least the subject of active litigation, and so I'd love to give you my views on that, but I can't. Although I would, since I'm at Duke Law, I might say you might want to read a concurring opinion from Duke alumni Judge Todd Hughes, who I think is a tour de force, but anyway, so the hiring, so the way that the judges are hired, it's atypical. It's an announcement in USA Jobs, or they're classified as, we're not on the GS schedule, we're administratively determined, which is some sort of category all of its own. It's not senior level, it's not SDS, it's AD. They're 1222s, the classification for sort of classification geeks, which is patent attorney in government speak. And so the hiring process proceeds much like the hiring of any other career employee at PTO, with the exception that once the initial hiring determinations are made, then we, by statute, and with your help now, have the director of the agency takes those names that we've recommended, further recommends them to the secretary, who may then sign the appointment letter, and then they're hired in. As far as protections for removal go, I mean, we've always understood that as the traditional, performance and conduct sections, which are just, my mind is blanking on the Title V, but it is, the judges have a performance plan. And if they, don't perform under the performance plan, they can be removed for efficiency of the service. Same as if there's conduct, if they get into a fist fight in the elevator, they can be, removed for that kind of conduct. We've never had that, by the way, but hypothetically. So those were the protections that at least pre recent case we had understood, is that so there was a procedure for either conduct or performance to remove judges for efficiency of the service. It was rarely proposed or done, fortunately, but that was sort of the route under which we proceeded, which was the same pretty much as any of the other employees at the office.
But not for Schedule C employees, right?
Right. So they would.
OPM.
I'm gonna make sure we
I'm sorry.
include in the next 2 minutes.
Okay. Yeah. I'm just curious. I mean, do you, on the immigration front, do you have, is it similar?
Yeah, immigration judges are not Schedule C employees. They are classified by the Department of Justice as attorneys, so they're treated essentially like other employees. Now, whether, some of the recent decisions that other panelists have talked about, whether they may be inferior officers and whether that may have ramifications for their removal ability, that's the subject of litigation. The Department, DOJ, has a position on that. They've expressed in their briefs, so I can't really get into it. But unless and until that issue is settled, they're generally classified like other employees, other career employees.
So on that note, I think we will thank the panel for taking time out of their